Thank you so much, Indian American Muslims Council, for inviting me for this talk. India, not as a nation, but India as an idea, has a very rich and unique history. Now, what we are witnessing in India, broadly speaking, in my opinion, is a deep churn. And this churn has to be understood. When we see at the BJP, the party in power today, and we see its influence and we hear these stories, it's a kind of perplexing at the start to understand how this change came about. So last 50 years, BJP, fueled by the RSS, has very craftily cultivated an alternative narrative to India. The systematic capturing of institutions, judiciary being, of course, one of them, but there being other institutions, for example, the Election Commission of India, for example, the police, for example, the civil society, and a systematic decimation of the civil society in India. The major problem, as I see, or the challenge, as I see, with the Indian judiciary, the first one is that there seems to be a lack of predictability, uniformity, and procedure being followed in the way that it is supposed to be followed. So let me begin with the first word, right? That is lack of predictability. Now, any legal system is based on the idea that legal principles will be applied similarly to similar situations. But when people see that in India, as all of you may be aware, there was this huge furor against the whole Tablighi Jamaat issue when the COVID-19, was at its peak. And then we had the Jagannath Yatra case. And some of you may know that Jagannath Yatra is basically, a procession taken off Lord Jagannath, who is very, very popular in Orissa, the state of Orissa. And it is usually visited by thousands and thousands of people, if not lakhs of people every year. The court said that it's going to allow the procession, of course, with limits. But I mean, nothing prevented the Supreme Court from a common person's perspective to invoke the ground of health. Health being a concern, we didn't necessarily need this procession, right? So where is the same treatment, one may argue, without going into the intricacies of the various legal arguments that the lawyers, of course, put forth in the courtroom. Let me give you another quick example. Now, Sabrimala, as some of you may have heard, it was challenging a practice in a very popular temple in the state of Kerala, where women of a certain age, basically menstruating age, were not allowed entry into the temple at all. And the Supreme Court, in its judgment, said that this practice is discriminatory against women, and that was hailed by everybody, only for the judgment later to be subjected to a review petition. So why this kind of exceptional use of review powers, when for 7 decades of the Supreme Court's jurisprudence, review power has never really been used like that, is a question that remains on the minds of many. And then let's talk about procedure. Now, all of you may have heard that the anti-CAA protest in India, specifically in Delhi, was widely covered by the media. The Shaheen Bagh was obviously a prime example, but there were at least 13 other protest sites that had sprung up in Delhi in different parts. Just to give you one example, it became hugely popular. You can all read it on media. Is a case of Safura Zargar. Now, Safura Zargar is this young woman who was basically, dissenting against the Citizenship Amendment Act. And the FIR said that she was trying to block a road and therefore apparently allegedly had a role in the communal riots that broke out, in the aftermath of these anti-CAA protests. And she was in jail for a very long time before being finally released on bail. But when there is such flimsy evidence, right? How do you hold these young people in jail, for such a long time? The moment police picks up a person, arrest a person, the police is required to release their information at the local police station. Basically, there should be some information of who's been arrested. And there are thousands of people who have been arrested. And even when 150 days had passed, none of this information was in the public domain. But we were hearing reports where police personnel across Delhi were in one way or the other not allowing the lawyers to meet the people who had been detained and arrested, thereby ensuring that the fundamental rights, to every arrested person is being denied. And then the second challenge that the Indian judiciary, I think, is facing is this slow action on some matters and inexplicable speedy action on others. About the Arnab Goswami case, and everybody in India is asking, how does a journalist, Mr. Arnab Goswami, gets such an expedited hearing at the Supreme Court, where several other national importance matters, talking about Article 370, abrogation of Article 370, right? It's been more than a year now. There has been a plea filed in the Supreme Court for initiating the hearings. More than a year, and the hearings in the Supreme Court on Article 370 has not begun. Now, why has the Supreme Court taken such a long time in hearing the batch of petitions related to Article 370 is a question that needs to be answered. When the Supreme Court started hearing the Babri Masjid Ayodhya dispute, the Supreme Court Chief Justice then, Mr. Ranjan Gogoi, had made it very clear that we are going to look at this as a title suit. It's a land dispute, right? What the Supreme Court ends up doing is saying the entire disputed land goes to the Hindu side, so to say, and the Muslim side should be given a 5-acre land in a prominent place in the city. That yes, it was a title dispute, but it is not a question of just any parcel of land. The question was that what existed on that historical place and just giving another 5 acres of land somewhere else, does that even go to the heart of the matter that the Supreme Court spent so much time hearing? So that judgment, of course, I think is a big blot, and I do think, without mincing words, that it's a judgment that will be seen by history in a terrible, terrible light. If the Supreme Court is to be, if moving forward, if it thinks that people's faith needs to be, in a way reaffirmed in the Supreme Court in particular, and in the Indian judiciary in general, it's very important that we go back to the basics, we go back to the roots. And at the moment, the roots, unfortunately, seem terribly shaken.